The government maintains that it has the authority through the NSA to collect large amounts of metadata and to store that metadata on a database, basically with respect to telephone and email communications of pretty much every American. And it purports to have the authority to store that, hold it over a long period of time, and when necessary, perform searches to figure out, connections based on national security concerns, to identify leads that it might follow up on. As I understand it, the searches on that database are governed largely, if not entirely, by internal NSA rules. There's no external constraint on that, certainly no warrant requirement or anything really approaching it. Those who defend this program and this practice insist that under Supreme Court precedent, most notably Maryland versus Smith, that the government has the right to do this, and there's no real Fourth Amendment problem with it. Maryland v. Smith, of course, was a case decided on a 5-4 margin back in 1979. It was an opinion authored by Justice Blackmun, and it dealt not with that kind of mass data collection. It dealt with data collection as against a single suspect in a single criminal investigation using a pen register. Do you think there might be different Fourth Amendment interests at play where we're dealing with a much broader scale, where potentially, theoretically, every American is the target of the kind of data collection at issue with what we're talking about today?
Thank you, Senator. It's a very interesting question. You and I spoke about this a bit privately, and I hadn't thought about it much then. I've tried to think about it more since and read some cases. Actually read a paper written by a second-year Harvard Law student about this. It's a really interesting question as to whether the Fourth Amendment framework that is in part embodied in the Smith case applies as technology changes, or whether, I think as Justice Sotomayor wrote in the Jones case last year, we ought to think about it differently, where each of those pieces of metadata is allowing the government to sort of put together a mosaic about you that goes beyond what you would normally expect and intrudes into a reasonable expectation of privacy. Fascinating question. I don't think it's settled. I hope it's one. I'm going to ask if I'm confirmed that the Department of Justice is thinking about. So I don't think there's a clear answer to it, but it's a reasonable question to ask.
Okay. I appreciate your willingness to keep an open mind on that issue. I think as you look at that and as you review, as the court in Maryland v. Smith did, the precedent in Katz versus United States, and you asked the two questions asked in Katz. Number one, whether there was a subjective expectation of privacy in the case at hand, and number two, whether that expectation of privacy is one that in objective terms society could and should regard as reasonable. I do think you come to a different conclusion. I think you have to come to a different conclusion with regard to this. So I appreciate your willingness to consider that. Would you concede, as I suppose you would, that it would be different altogether? Let's take in the case of email collection, surveillance of emails. It would be an even easier question with regard to the collection of content of emails.
Very much.
And
that's the difference, to use the 1970s analog, between reading the outside of an envelope and opening it and reading your letter.
Right. So that you wouldn't see any substantive distinction between the government opening somebody's mail and the government opening somebody's email to read the content of it.
I don't. I've always thought of it as a Fourth Amendment event.
Right. And yet, it's interesting, the law in this area, the ECPA law, there's a particular title within ECPA that allows government agents, simply by sending a request to an email provider, to read the content of someone's email, not just the metadata, but to obtain the substantive contents of the email communication. Once that email has ripened past the age of 180 days, that seems to me to be a problem, and it's one that Chairman Leahy and I have been working on together. This is a loophole that we're trying to close. But would you agree with me in concluding that for Fourth Amendment purposes, there's no no discernible, constitutionally significant distinction between an email that is 179 days old and one that is 181 days old, with the former being entitled to Fourth Amendment protection and the latter being entitled to nothing.
I would, Senator. I don't think the Fourth Amendment has, like your yogurt, and expires on date on it. I was unaware, as a prosecutor, of that 180-day. I always thought of it all as content that I would need probable cause to get. So I'm aware of that, and I think the department is also working to see if that can't be fixed. It sounds like an anachronism to me.
Yeah, I think it certainly is. It's an anachronism. It was anachronistic even at the time, in the sense that I think it was incompatible with the Fourth Amendment. But it's easier to understand why it didn't raise eyebrows then, because people typically didn't store emails any longer than that. And so maybe one could have made an argument back then that nobody was concerned about it, therefore no reasonable expectation of privacy could develop. I certainly don't think the same argument can be made today, and I'm pleased that you as a prosecutor never went down that road. I know I certainly didn't, but there have been some within the government who have suggested that this is an appropriate option for government agents to pursue, and I hope you'll stand with me in recognizing that there's an important Fourth Amendment interest at play.
If there are, they're going to be unhappy with me, but I see it as you do.
Okay.
Yeah.
Thank you very much, and thank you, Mr. Chairman.
Thank you very much.